Mr. Clayman.
Good morning. Please, the court. My name is Richard Clayman. I'm from Chelsea. Here with my partner, John Dodge from Chelsea, and this is Nunez, the mother of my client. May it please the court. On May 11, 2002, my client was 18 years old. He was involved in an automobile accident. Proceeded through an intersection that was green. Another car went through the intersection through the red light. A collision occurred. The other car was going 11 miles an hour. My client was going 47 miles an hour. The impact occurred. It's a terrible accident. It resulted in very serious injuries, paraplegic to the present day. I was retained by the family, and I brought an action against two commercial establishments where my client, the plaintiff, had been consuming alcohol earlier in the night in question. The evidence was that he was consumed within a 2-hour period 6 Grey Goose vodka and sodas at Carrabba's establishment, represented by my friend Mr. Emanuelson. Left the establishment, went home, took a shower, vomited, went to the second establishment, known as the Palace, represented by Mr. Dreschler, consumed 2 other alcoholic beverages, left, and within a matter of moments was involved in the automobile accident. I commenced an action based on 2 causes of action referred to in Mr. Justice Gantz's decision in the summary judgment. I alleged that the commercial establishments were responsible because, number one, they served an underage patron, underage being someone under 21 years of age, and that a jury should consider that fact and determine whether or not there's a causal connection between that act and the incident, and that I'm entitled to consequential damages. I brought a second cause of action, saying that those commercial establishments are responsible because they served an intoxicated person. Different cause of action, under 13864, saying that because of that act, they are responsible for the consequential damages. Mr. Justice Gantz, in his 15-page decision, said in essence that he thought my client does have a cause of action on the basis that the establishment sued an underage person, and that the pertinent age, the relevant age in question, is 21 years of age. Because there is a statute, 231, Section 85T, that says if a commercial establishment serves someone, and that someone is injured, the burden of proof is willful, wanton, reckless conduct. Mr. Justice Gantz said when you're dealing with a cause of action to a minor, someone under 21, the burden of proof is only negligence. Judge Gantz also said, though, that when you're bringing a cause of action against an intoxicated person, 231-85T says the words intoxicated person, and therefore you have to prove that the patron, my plaintiff, was intoxicated, and the burden of proof under 231-85T is willful, wanton conduct, and he didn't see it on the record. I say that Judge Gantz was right vis-a-vis the cause of action against an underage person. The burden of proof is ordinary negligence. I agree with Judge Gantz.
That's count 2. That's count 2.
I think it was count 2 in the way I wrote it. That's count 2. And that I think Judge Gantz should be upheld by you people respectfully, and I can have my jury trial. But I then say I think Judge Gantz was a little short, didn't give a good look at the standard of whether or not I'm entitled to go to the jury on the basis that they served an intoxicated person and that willful, wanton, reckless conduct
What evidence
applies.
did you have that he was visibly intoxicated at the time he was served?
I don't have a lot of evidence that he was visibly intoxicated, but I've read your decision on that a while ago. And I think the law is, respectfully, whether he was visibly intoxicated or whether the establishment should have known, reasonably should have known whether he was visibly intoxicated. In the appendix, we do have in the record certain notations on page 196 where Nunez said in his deposition, you could tell the way I was acting after 7 drinks that I was drunk. That's in the record. He said on page 196 in the deposition, when I was drunk, you just kind of get a wandering look Well, like you are talking to someone, but you're kind of looking off to other people. That's on page 196 of your appendix.
And to what extent...
And other references.
And to what extent does his age play into that, if at all? I mean, is that a purely factual question?
Onto the intoxication basis, it plays no... It has no room. It means nothing. It's whether or not he's an intoxicated person. In my case, I think it's part of my argument, because I think that in addition to that he was intoxicated, and whether or not he appeared intoxicated, it's relevant that he was underage. That's part of my argument.
Well, your argument, I take it, is that it's relevant to whether the conduct was willful, wanton, and reckless.
Yeah.
That in fact the person was underage.
It's certainly relevant
that's
to
part
that.
of the.
Yes.
That's more than just negligence, right?
All the cases, every case that's ever been talked about this issue, always says the same thing, that we treat minors different from we treat people who are not minors. That people who are minors or under 21 are less susceptible to bad judgment. They have to be careful.
Well, they're not minors in it. I mean, they are adults.
They are adults, but they are under 21. And all legislation in the Great and General Court has looked at the issue over the years. 13834 has been looked at and modified. We all remember.
Well, it makes it a crime for underage people to buy and for persons to either give or sell alcohol to such persons. But does it create a civil duty on top of just a criminal fine?
Well, I think the civil duty exists under a Damien and their progeny. When a party is negligent, when a party violates a statute, that at a minimum, Judge Cordy, is
that may be evidence of negligence.
Evidence of negligence at a minimum. In my case, not only do I have that evidence, but my man was underage, and my man, I submit to you respectfully, if you look at the totality of all the evidence, clearly a jury could find
But why isn't
that he was intoxicated.
85T trump that? 85T providing that the tavern owner
Yes.
who serves someone who's intoxicated
Yes.
is only liable to that person for
Yes.
injuries that person causes themselves. We're not
Yes.
talking about innocent third parties here. We're talking about the injuries to the person. If, in fact, the conduct is wanton, willful, or reckless. Why doesn't 85T set the civil standard here?
Well, first of all, it doesn't set the civil standard because your court in the Norwood Country Club, Norman versus Norwood Country Club, said it didn't.
Well, it doesn't for minors.
Well,
Right?
it doesn't
For people under 18 years of age.
Well, it leaves open. That's why I'm here. I guess it leaves open that gray area as to 18 and 21. But certainly it is a cause of action. You can allege a cause of action for negligence. 85T, I think if you read the legislative intent, they wanted to prevent those people who voluntarily went into an establishment, who voluntarily consumed alcohol, of having a cause of action against the person who serves in the alcohol. The Norwood said that doesn't apply to people who are
Minors.
Well, it's tricky for me.
No,
Minors,
under
but-
the age of
right.
18.
Under the age of drinking. Under the age of drinking.
18.
And the age of drinking today and back then is clearly 21. If this had happened back in 1983 or whatever that year was when the Great and General Court had the drinking age at 18, my position would be much weaker. But it didn't. It happened 4 years ago when the age was 21. And really, in all due respect, the common sense application is everyone knows, every court knows, the drinking age is 21. When the ABC people go out every Friday night all over the Commonwealth and do a sting, they bring 19-year-old police cadets. The drinking age is 21. My client was not 21. My client was 18. And that's just what the legislation and just what the Norwood Country Club case says.
But your client, I mean, your client has violated the law by having illegal identification and illegally purchasing alcohol, and the establishment has violated the law by selling it to someone. All right, but that's got nothing to do with civil consequences. That's just got to do with the sort of criminal scheme or the regulatory scheme. We're talking about civil consequences.
Yes, Your Honor.
85T says, no, we've modified that by saying, well, when you deal with people under 18, the statute didn't envision protecting bar owners in those circumstances.
Yes.
But now we have an adult. This is an adult. So why should we ignore 85T when it comes to adults?
Because Norman should be extended or interpreted better, that when we're dealing with the consumption of alcohol, the great and general court and all of you people in the past have decided that the legal age for drinking, consuming alcohol is 21, and anyone under 21 does not have the maturity, the judgment, or the ability, the level of maturity to recognize that the consumption of alcohol is dangerous. That's why the drinking age is 21.
To claim
That's
that-
why
is it-
85T is trumped by that.
Is there anything, and I know, there's a little reference in it, the briefs, that the legislature, when it raised the drinking age from 18 to 21 in 2000, whenever it was, that it intended to sweep within that liability for civil liability for people who served underage to minors within the meaning of the new statute.
Who would have written it? Didn't. Who would have written it, Your Honor? Who would have said it? Doesn't say that.
If I understand you, Mr. Clement, am I correct that you would like us to take the Norwood Country Club case and say that based on its language, it includes those who are 18 to 21?
Yes, Your Honor.
Because they're minors for purposes of being given alcohol.
For purposes
So
of
it'd be
giving
sold
alcohol.
alcohol.
Right. Underage consumption of alcohol is under the age of 21, notwithstanding the fact that someone may be an adult for a period of 3 years.
Can I ask you a question about the facts?
Yes, Your Honor.
Regarding your client, did he use some kind of identification to get served?
Not in the facts in this case, the answer is no. And that goes to this, all irrelevant. The facts in this case, first of all, there's clearly a genuine issue of fact of what I'm saying, but the record indicates strongly, that my client was 18 years old. He went to this establishment because he was friends with the bartender.
Which one?
Carrabba's, the first one, where he had 6 drinks. And there is strong evidence that he had 6 drinks. And by the way, after the accident, when he went to the hospital, he blew a 14. His blood level was a 14. We now know under 9024 the important level is 8. He was 14. Back then the important level for criminal purposes was 10. He blew a 14. He went to that establishment. He knew the bartender. The evidence is strong. They were friends. They both had those telephones where you calibrate it and you talk to him. He went there repeatedly to this establishment. The evidence is strong that he went repeatedly to both establishments and repeatedly consumed alcohol over a period of time while under the age of 21. And the record is replete with that throughout the appendix. I can give you those references if you want to. He went there knowing he was going to be served alcohol. The bartender was like John Dodge to me, being the bartender. Didn't pay, went up there, showed no ID, consumed 6 drinks.
Well, let me ask you that. Showed no ID. I know there are fact issues out here, but I take it. Let's talk about the Palace first, which is the last place he was drinking. I take it that he had used that ID in the past.
Yes, Your Honor.
And therefore they knew who he was.
Yes, Your
Honor. And the
Honor.
ID was a false ID.
Yes, Your Honor.
Okay.
That's in the record.
All right. Let me go back to 138, Section 34, which is this statute that makes it a crime for persons to buy alcohol who are under 21 or to either sell or provide it to someone under 21. That was amended in year 2000. What was the nature of the amendment in 2000? Do you know?
Not offhand.
Okay. Well, you know we have at least some case law that suggests that a social host does not have any liability to someone who comes to their house, consumes alcohol, and then injures themselves. Correct?
I agree with that, Your Honor.
Well, why isn't that liability, that duty that you're talking about under 138, Section 34, applicable there as well? If that's the basis of the duty, Why isn't it applicable to social hosts?
Because of the analysis in the Norwood case, which is the last one that's been decided, where they say that you should, and they did, differentiate between social hosts, you and I having people at our house and they're having a few drinks, versus a commercial establishment for 4 reasons. They said, number one, a commercial vendor may financially have an incentive by being more careful, and that should be considered. That a commercial establishment can closely control and monitor the patrons, and that they have experience in doing that, which social hosts do not. That a commercial establishment has experience in identifying and managing people who have consumed alcohol, which you and I may not have in our home. And number 4, they said because a commercial establishment can insure against those problems. And we know as a practical matter, all do insure against those kinds of occurrences. And that is why all of the cases, or at least the Norwood Country Club case, makes a detailed analysis, Judge Freed, saying that you have to differentiate between commercial establishments and social hosts. And they talk about the paternalistic view that we must have to people under 21, and that they choose not to bring that to social hosts. This case here, if my position is adopted, does not change the law in this Commonwealth vis-a-vis social host liability. Supreme Court's made it clear all the way through they choose not to change that law. My brothers will argue that does apply, that you have to cross over and apply the social host law, quote unquote, to the commercial establishment law. That's never been done. Shouldn't be done. Bottom line,
Thank
if
you,
I
Mr.
may I have one last sentence?
One sentence.
Thank you. I submit to you respectfully that my client should have his day in court before a jury. He should be able to lay out all these facts and let the jury decide whether or not parties were negligent, whether or not parties were willful, wanton, vis-a-vis the service of intoxicated alcohol, whether or not comparative negligence does or doesn't apply. We should have our day in court. Thank you.
Thank you, Mr. Kamen.
Thank you.
Mr. Emanuelson, I understand that you're having 7.5 minutes.
Yes.
Thank
Does the timer show when it's 7.5?
Yes. How much you have left?
Thank you. As you know, I am Roger Emanuelson. I represent the defendant appellee, Carrabba's Italian Grill. There are clearly 2 issues in this case based upon Judge Gant's ruling on the motions for summary judgment. First, it is finding that Chapter 231, Section 85T, which requires willful or reckless conduct, does not recognize, or he did not recognize, that it applies to that subgroup of adults who are minor drinkers. In other words, they're between 18 and not 21.
Could I clarify something
Yes.
right up front? Section 85T talks expressly about the imposition of liability for serving to an intoxicated person.
Yes.
And that's all that it covers. I must say, I don't see what Section 85T has to do with a theory that is based on serving to someone who is an adult but underage drinker.
Well, I think because Tobin versus Norwood Country Club did address that issue, although in that circumstance...
Tobin allowed it to go forward on a straight negligence theory?
Because it was a 17-year-old girl.
Well,
She was not in that subgroup that we are talking about.
well, Section 85T only talks about claims of service to an intoxicated person.
But they mean, I believe, that statute means adults.
You think that in... but
Because the standard
if the-
to serve a person who is a clearly minor, the standard is negligence.
Sure.
It's not willful or reckless.
Okay, but I mean, even in the 18 to 20 category, if you're serving someone who appears to be sober, you are not, no matter what their age is, you're not in the realm of Section 85T. You're still, seems to me...
Well, that's the whole crux of our position, is that the second ruling by Judge Gantz, that there was no evidence of willful or recklessness in this case is clearly supported by the facts.
That may be, but I'm not. I mean, the reason why it comes into play is because if we read the very broad language in Tobin, which clearly, and I'm looking at particularly page 134 to 135, to apply to a minor. I mean, the language talks in terms of teenagers and so on and so forth. Then you've got that lower standard.
Yes.
And then you cannot determine, I take it, as a matter of law, that you can't get to a jury, correct? So if we extend Tobin to the 18 to 21,
Yes.
then you don't have the wanton, willful, reckless standard. You have the lower standard, and therefore you cannot conclude as a matter of law that summary judgment should be granted. You go to the jury on this record, correct?
That would be correct.
Now,
and
let me-
that's why we're here.
Right. Mr. Emanuelson, if you agree the bar can't use the statutory defense for a person they serve who's 17.
Correct.
Right, that's the law. Why should the bar be able to use it for someone they serve who's 18 or 19? Why aren't they both in the same class for public policy purposes?
Because this court and many jurisdictions have recognized that people 18 or older are in a different criteria. They could do many things. They can enter contracts. They can enlist.
They
in the
can't be
Army.
sold alcohol.
Except that they intentionally. It's a social issue.
Yes, but our legislature
You know?
has deemed them all the same, those who are under 21, and the legislature has not
Well,
drawn a distinction between 17 and 18 and 19-year-olds.
I think that's the error that Judge Gantz made, which probably on the case law, because in Tobin, this court declined not to decide that issue, but recognized that it is an issue. But he equates violation to the criminal statute, 138, which has sanctions, as this court recognized that you were asking Mr. Klayman, to say that per se applies to the civil side. And we say that's not the right standard to apply, that this young man was an experienced drinker, had been drinking at least by 16. He was working for a firm that solicits people to send them to drinking establishments. He drank regularly at many different establishments, and went to this my client's establishment that night, and for this purpose, I mean, there is a dispute on facts, but for the purpose of this motion, we assume that he did drink, and perhaps drank 6 drinks, but left, had no apparent ability to drive. His companion said he had no concerns the way he drove. He went home, made a decision to shower, made an adult decision to then go back out, go to the co-defendant's establishment, drink there.
You left out a fact,
Yes.
that he vomited while he was at home.
Well, all the experts seem to say that doesn't matter. But he did do that. He has testified to that.
But again, Mr. Manuelson, it doesn't. The question is, does this plaintiff get past summary judgment? That's the
Correct.
That's the issue. So
Correct.
all of this post hoc.
Well, that goes to the willful wanton
Well-
area, which is the second part of Judge Gantz's decision, which we agree with, obviously. We just don't agree with the first part, which is that he says because this establishment served a person under 21, it trumps 85T. And
Well, it doesn't trump it. It simply interprets it in a way that, one way to look at it, it interprets it in a way which is consistent with what the legislature is doing, which we described, which said, we think that people up to this age, yes, they may be able to vote, they may be able to do all kinds of things, but they are known to, engage in ultra-hazardous activity. If you put somebody behind a wheel And the legislature made a decision and said, until you're 21, you don't realize how dangerous it is. He obviously didn't realize how dangerous it was.
Well, it's a social decision, and we're asking this court to make that decision. Whether he's 18 or 21, in this society today, young people are drinking when they're over 18 and under 21, and making intelligent
No, they're not making.
Maybe it's not an intelligent decision.
No, the legislature
But they go to an establishment and decide they're going to drink.
But
And that's what happened in
But
this
hasn't the
case.
legislature made that decision for them?
Well, what we're asking is for you not to let the legislation decide this, because this is a social decision that this court, as a body, should make this decision as to what standard should be applied to these people that make an intelligent or non-intelligent decision, but as 18 or older, that they're going to go there, they're going to drink, they're going to lie to the people that are serving them.
Shouldn't you be addressing your argument to the legislature?
No, because we are in this forum, and we're asking you not to leave it to the legislature to make that decision. It's a very, very important legal distinction that this body should make, and I am using up my
Thank you, Mr.
co-defendant's
Mandelson.
time.
Mr. Drexler's getting anxious there, but Mr. Drexler, you get your full 7.5 minutes.
Thank you
He didn't
very
eat into your time at all.
Judge, I'll try to be brief. I'd like to say a couple things about the standard. If this court is of the view that 85T doesn't apply, then I think the issue has to be addressed in terms of what standard do we apply to a situation where someone injures themselves, is 18, 19, or 20, and it uses a fake ID, as we have in this situation, to gain access and familiarity with the premises and allow themselves to be served. In Ganius versus Hamilton versus Ganius, this court decided that against or in favor of the social hosts. In other words, in the absence of a statutory standard, this court applied the reasoning that it applied in Manning versus Nobile, which was simply that a social host has no liability, even when the person is an adult for all legal purposes, but a minor in terms, or underage in terms of the legality of service of alcohol. And I point to the language in Tobin because I think it's particularly persuasive here. Obviously, this court expressly left open in Tobin the issue of whether or not the higher willful wanton standard applied to a situation where the person is 18, 19, or 20. And the court had an opportunity there to say, hey, 85T doesn't apply, or at least that standard doesn't apply, or it shouldn't be the standard we apply, but they didn't, and they expressly left it open. And here's why I contend that they left that open.
No, wait a minute. That Tobin allowed that suit to go forward, or actually affirmed the jury verdict, where it had been submitted to the jury on a negligence theory with comparative negligence. There was a 40% reduction. That was left in place. Comparative negligence isn't there when you have reckless, willful, wanton. It seems very clear for the 17-year-old in Tobin, negligence, comparative negligence, straightforward application of normal negligence principles. I didn't see anything about 85T being left open in Tobin.
Well, actually, they said that on page 137, when we have a case like Hamilton, but involving a commercial licensee, Hamilton being an 18, 19, or 20-year-old, will be time enough to determine which definition of adulthood covers the duty. And in Hamilton versus Ganius, this court pointed out all of the attributes or all of the privileges that people who are 18, 19, and 20 enjoy as adults from a legal standpoint. The only thing they can't do effectively is drink. What's interesting in Tobin is the language in which the court says in Hamilton versus Ganius, in which the defendant was a social host, the injured plaintiff was 19 years old. What we said in that case, far from contradicting our decision here in Tobin, supports it. Now, Tobin is a 17-year-old. They then go on to quote all of that language from Hamilton, in which the court recited all the privileges enjoyed by legal adults who are 18 or over. The way I read that, is that the plaintiff in Tobin was 17 and does not enjoy all of those privileges or rights. So I believe the significance of that sentence when they say what we said in that case, meaning Hamilton, far from contradicting our decision here, supports it.
A two-way to leave there. One is it's dealing with social hosts.
Yes.
And the other reason, frankly, why courts don't address it is because we don't have this particular plaintiff. We don't have the person between 18 and 21. The nub of the problem, as you understand, is, from my point of view, is the legislature has said, look, whatever else we trust 18, this child is 18, 19, and 20-year-olds with, we're not going to trust them with alcohol. Why? Because we know that 18, 19, and 20-year-olds get behind a car, we're not going to trust them with alcohol, and so we're going to make it a crime for you to sell to a 21-year-old, to a 20-year-old, and we're going to make it a crime for a 21-year-old. That's how bad we think it is. So it seems to me if you read Tobin, why wouldn't we take that into account to say that everybody who proceeds here knows that there may be comparative negligence, of course, but that you're proceeding at your risk and you're not going to get a wanton, willful, and reckless.
Well, except that when the legislature passed the statute making it a crime for social hosts, for example, to serve alcohol, this court did not incorporate that into the law of social host liability. Despite that statute, this court said, we're not going to impose social host liability even on a category of plaintiffs who are 18 to 20.
If the legislature wants to do this, they can do it.
Well, and in footnote 4 of Hamilton versus Ganius, I thought was interesting dictum in which this court said, and it was dictum in that case, but having decided that there's no social host liability at all in the case of a plaintiff who injures him or herself who's 18, 19, or 20, the court in a footnote said there wasn't any willful wanton action in this case anyway, and almost implying, and again it's dicta, I understand, but implying that were you to apply a standard here for commercial establishment, let's say, you probably should and would apply the willful wanton standard. If you say that the strict reading of 85T doesn't apply, then it's up to this court to set the standard. In Hamilton versus Ganius, in Manning versus Noble, you made the decision, this court made the decision, that there's no liability at all on social hosts as a matter of public policy. In looking at the public policy issues here that are surrounding this issue, I suggest that someone 18, 19, or 20 who uses a fake identification as a means of gaining familiarity and access with an establishment, who drinks at one establishment, goes home. The vomiting, I suggest, is significant in the sense that this plaintiff ignored a warning sign that perhaps he should be home for the night.
The comparative negligence
Yes.
is, there's plenty of comparative negligence. The question is, do you even get to that, or do you get the willful, wanton, or reckless?
Well, that's the standard that I suggest you apply. And in looking, I did brief some issues about the legislative intent when 85T was passed, and I think it's somewhat reflective of what the intent was, but more importantly, what it was not. It seems to me that when the legislature passed this comprehensive number of statutes that created the LLJUA that imposed 85T, there were two principal concerns. One was to ensure that bars and restaurants could stay in business in the Commonwealth by being able to obtain insurance in an economical and reasonable way. But probably the more important thing that was cited by the legislature, as it should be, is the fact that we want to make sure that if people are wronged, third parties are injured, innocent third parties are injured by the actions of a bar, we want to make sure that there's going to be money available by way of insurance to compensate these people for their injuries. Now, nowhere in that discussion of the wisdom of that legislation was there anyone voicing a concern for people who go and injure themselves. This plaintiff, as sad as the injuries are, and they are, at 18 and a half years old, who appeared to be an adult who showed no indication of intoxication, who, again, and I know it's already been said about the fake ID, but really violated the statute himself by gaining access to liquor.
I understand the argument. Is there anything in our case law that says we treat differently people, and people? I mean, most of the cases that you've cited, there's been an innocent third party, correct?
There are cases for 18 to 21 with an innocent third party is injured, yes.
So where in our case law have we said when it's you who have engaged in the criminal conduct, we should treat you differently for these purposes.
I can only liken it to Hamilton versus Ganius, where you did recognize that there were people who were under the legal drinking age but were adults for all other purposes, and nonetheless indicated that when weighing that balance between social hosts and parties who injure themselves, we're not going to impose liability.
We simply held that, did we hold there was no duty?
Yes.
In those circumstances?
Yes.
No duty.
Now, if it was a third party, the innocent third party that was injured, I'm sure this court may well have reached a different result, but that wasn't. So that distinction was made there, and that's the closest I can come to making that analogy. Obviously, this particular issue wasn't resolved, and Tobin expressly left it open, and why we're here today. So,
Thank you, Mr. Burke.
thank you very much.